All righty, y'all. We're gonna start. I know there's gonna be people coming in as Nicole's presenting, but I want to respect her time. Um, Good morning, everybody. Happy Monday. Hope you all had a great last week. Today, for the first time in Monday Mortgage Minute history, I will not be speaking to you. We have a special guest here, Nicole Soto Ortega. She is a probate attorney, and she will be talking probate to you all today. Any questions that you guys have, I did ask you guys that were here last week, write down or make sure that you guys come with questions to ask her anything that you guys are curious about when it comes to trying to, get probate properties, close probate properties, things like that. But I'm going to give her the floor and let her introduce herself. Hold on, I can't find you on my screen. Nicole. Oh, here you are. Okay, perfect. Her. All righty, go ahead, take the floor.
All right, good morning, everyone. So I'm going to share my screen. Oh, wait, it says it's disabled. Can I share my screen, Mike, or no?
Yeah, I got you.
Okay.
Go ahead.
Okay, let me see. All right, let me know if you can all see that. I think should be good.
Yeah, we can see it.
All right, perfect. All right, so again, thank you, Mike, for having me. Thank you, everyone that's on this meeting. I think this is going to be a really good opportunity for you guys to, for those of you that may or may not understand the probate process and how this can ultimately be a really good business endeavor for any of you guys to take the opportunity to learn and really learn this craft well, so that you can create another line of business for yourself, as long as you take the time and the patience to learn what probate is in the world of real estate. So, wow, let me just, okay, yeah. So jumping right in, what is probate? That's the most common question that a lot of people have. They don't really understand what it means, but probate is essentially the legal process that we undertake to administer and distribute the assets of a person who's passed away. So there are different types of probate in the state of Florida. For purposes of this conversation, the examples and all the explanations that I'm going to be going through are primarily focused in what we call formal administration. So that's the more lengthier process of the probate process. It has a lot more to it. There's more nuances. There's more things that we have to get involved in. But like I said, for purposes of this conversation, it is for probate formal administration components. Oh, Mike, I don't know, do I have to admit the people that are in the waiting room, or I don't know, it's like little alerts are popping up on my screen, so I don't know if I have to do it or not. So continuing on, one of the most important things that people need to realize.
I was muted. Sorry, Nicole. Yeah, admit them because I'm no longer host because you're sharing.
Oh, wow. Okay. Got it. Good to know. Thank you. I'm glad I asked. Okay, I think we're good now. All right, so I'll just be vigilant of that. Sorry, guys. Okay, so moving on. So if you're just joining on, I know we admitted a few people, but all I've touched on really is what is probate. And like I said, there's different types of probate, and you only need to open a probate if there are probate assets. So that's the biggest, most important component that you need to be on the lookout for. And essentially, what is a probate asset is also the other common question that we get. So a probate asset is essentially any asset that's owned solely in the name of the decedent at the time of their death, or it's owned by the person who passed away and another person or other individuals, and there wasn't some sort of language or automatic succession, language or provision regarding the ownership of that asset that allowed it to automatically pass to the next person. So thus it would avoid probate, which is essentially what most people are always trying to achieve. So common examples of what the automatic succession language is for purposes of this conversation are owning property as joint tenant with right of survivorship, or owning property as husband and wife is what we like to call the tenancy by the entirety. Obviously, a tenant in common would be an example of how you will end up in probate. So just leaving that deed titled that way is obviously going to create a potential problem for you in the long run. Common examples of assets that could possibly be probated are bank accounts, real property, personal property. Like I said, anything that essentially isn't titled correctly that provides for automatic succession. So who are the probate parties? I think that's one of the biggest things that you guys need to understand in the transaction when you get involved in these types of real estate transactions. So you're always going to have the decedent. This is the person who passed away. This is the person who owned the asset that did not have some sort of automatic succession or provision for passing ownership of that property to the next person. Then you're going to have the personal representative. The personal representative, this is kind of like, think of this person as the person in charge. You know, this is the person who is selected either by a majority of the heirs and interests of the estate, or it's the person selected in the will of the person who passed away. This person will have the authority to make decisions on behalf of the estate. They're going to basically be the one driving the car through this whole process. This is also, which I'm going to touch on later, the personal representative is the person that you need to make sure is the person signing your listing agreement. This is the person signing your as-is sales contract. This is the person that's signing on the dotted line on anything and everything relevant and legal. So not any of the beneficiaries, not the attorney for the personal representative, not, you know, the spouse, not anything. It's the personal representative, and it's the personal representative that you have a court order that has designated that person as the personal representative of the estate. Then in addition to that, you'll have beneficiaries. Beneficiaries can oftentimes be the personal representative and the beneficiary, meaning that there's a sole beneficiary, so there's only a PR and that they're the only person receiving. That happens, it happens often, it's very common, but there are other circumstances where you can have, you know, I have a case right now, we have about, I want to say like 18 beneficiaries. We do have a PR, but there are what we call interested parties involved. So just know that you, if you represent that transaction, you may or may not be receiving calls or emails, whatever, texts, communications from beneficiaries. Remember, the person that you always will need to respond to, other than the attorney, is going to be the personal representative. So just know, like, sometimes these probates get really messy. They're like a real life Maury show. So, you know, brace for impact, but it might be a little fun and interesting because you're going to learn a lot. Another party that I do want to mention that can sometimes show up in a probate is what's called a curator. A curator, and I'm going to use Miami-Dade as an example, is always an attorney. The curator is what we like to call, essentially, it's a neutral, disinterested third party. They're typically appointed temporarily because oftentimes if the beneficiaries or the individuals involved can't agree on who should be the personal representative, or there's some sort of litigation, the court will appoint a curator to hold that seat and essentially, like I said, drive the car through the process. Now, remember, the curator is a temporary position. So once a personal representative does get appointed, the curator's role will end because there cannot be a curator and a personal representative sitting at the same time. The personal representative will take precedent over the curator if one is appointed. So a curator is also entitled to compensation for their time. And remember, like I said, they are an attorney. So just bear in mind that if you are dealing with a curator, you need to ensure whether or not the curator has the authority to sign on your as-is contracts, your listing agreements, whatever the case may be. Cross your T's and dot your I's when it comes to that. So essentially, what does the probate timeline kind of look like for the most part? So like I said, we're focusing on what a formal administration is, because in what we call a formal administration, that's the only type of probate that will allow you to sell real property, which, like I said, I'm focusing the probate topic to real property, because obviously that's what matters right now in this conversation. So you open a probate, you open it with the court. Again, I'm going to use Miami-Dade County as the example because I think most of us are professionals in this particular area. So you open the probate and then you essentially petition and you get your personal representative appointed. If you have everything kind of set up and kind of all the documents signed, your client's really, complacent and they're kind of like, a responsive client, you could get a PR appointed within, maybe like 2 weeks, give or take. Then after that, once you get the PR appointed, this is the waiting period. And this is probably what could drive, a realtor or any agent probably a little crazy, because it's a 3-month publication creditor period, meaning for 3 months, we essentially just have to sit, on our hands and wait until the 3-month process passes. And this is basically to give any potential creditors an opportunity to file a claim with the estate. Now, we like to always hope that there isn't a creditor, but if there is, it's something that we're going to have to deal with after the 3-month period. So as you can see, the next process is we address claims and any miscellaneous issues that have arisen in the estate. Now, let's hope that this is a great scenario. No creditors have appeared or anything like that. We're going to go ahead and petition to sell real property, which is part of our distribution. So when we petition to sell real property, and I'm going to touch on this in the next few slides, it's a very, I don't want to say particular, but it does require certain things be presented to the court, because you'll need to, state that it's an arm's length transaction, that it's, the price that it's being sold at is, fair market value. Some of the documents that we'll have to present to the court and to other beneficiaries and to the judge for review include, like I said, the as-is contract, sometimes the listing agreement they like to see, the broker letter, they'll like to ask for comparables, anything to substantiate the value and the sale that is going to take place. That's the evidence that we put forward. So when the attorney is kind of, you're working with an attorney or in a law firm that's doing this petition to sell, make sure that you are forthcoming with all of this information and that, you're timely producing these documents, because, just as badly as you guys want this sale to happen, we want to get out of this estate. We want to be done, wrap it up, get out, get in, and we're out. So once we do all those distributions, let's say the court, approves the order, all the distributions happen. We then will ultimately discharge the personal representative and then close out the estate. So like I mentioned earlier, these, and again, I'm using Miami-Dade as an example. These are the blank court orders that we submit to the judge. We're obligated to use these, what we call smart forms in Miami-Dade County. And one of the things that I do recommend you as an agent, make sure that if you are dealing with an attorney or a law firm that is doing probate and there is a probate transaction, I think it would be wise of you to just kind of confirm that the individuals that you're working with do have the proper authority vested in them to sign on the dotted line, like I said. So I think it would be wise to ask for, hey, can you send me a copy of the order appointing personal representative? Can you send me a copy of the letters of administration? 1, this shows that, you're professional. 2, that you're knowledgeable on what's required by law in this transaction. And 3, you're covering yourself to make sure that whoever you're having sign these documents actually has the proper authority per the court to sign these documents. So one of the things that I want to point out on these, and why, I know some agents may get not frustrated, but they may get, kind of, I guess frustrated is a good term, because, it's like, why is this process so long and so hard? And it's because of these particular, and if you can see paragraph number 3, it says, if Florida real estate is sold per court order, a closing statement shall be filed and the sales net proceeds shall be placed in the depository. That same restriction is also placed here on the other letter of administration towards the bottom, the same exact restriction. So us as attorneys, when we're doing these probates in Miami-Dade, we're obligated to follow everything. We have to sell per court order. Everyone has to be legally authorized to sign everything. We have to produce all the documents that are part of the probate and the real estate transaction. And then all the money that goes in there from the sale of that property is going to get placed in a blocked account, that the only way to get that money out is per court order. So if you want to make sure that you get paid, make sure that you appear on the closing statement, because that closing statement is going to get paid out like that. And then the remaining money, it gets blocked into the estate blocked account. So again, cross your T's, dot your I's, make sure you're getting paid on the closing statement. And then this is that order that I was referring to about the blocked accounts in Miami-Dade County. It doesn't have any strictures regarding the real property or anything like that. But this is just so you know, this order exists. And this order is basically what's telling us we have no other choice but to put the money in the blocked account. So I guess to kind of essentially almost wrap things up before I open up for questions, I guess probate in real estate. So what's the big deal? So I think one of the most important things for you guys is to create and solidify relationships with attorneys and law firms in this particular practice area. So I think a lot of people don't realize how untouched this market can be, especially here in Miami-Dade. And I kind of want to jump to the other side of my screen really quick, because I think it all ties in. And I don't know how many of you are into doing these cold calls or anything like that, but I did a quick search on, that phrase right there, estate of, on the property appraiser's website for Miami-Dade County alone. And I did it on Friday afternoon. Friday afternoon, over 6,000 properties came up showing estate of as being owned by, quote unquote, an estate. That means there are 6,000 potential leads that you guys are leaving untapped that need to essentially either open up a probate, and I was talking to Mike about this beforehand, but these transactions open up the opportunity for a lot of business growth for not only you and an attorney, but one, you can cold call, obtain these leads, and these properties, when they're titled in a state of, they're stuck there. They cannot do anything. They can't get a HELOC, they can't refinance, they can't sell, they can't do anything. They can't take out a second mortgage. That property is frozen in time. So I think one of the best things that you guys can do is maybe consider reaching out to some of these, whether either mailing out a pamphlet, getting in contact with whoever the property owner is, and just, making them knowledgeable of their options and the restrictions they have when the properties are titled like that. You can bring those leads to an attorney that you work with or that is knowledgeable with this. And then if you're bringing an attorney 6 probate cases, what makes you think that that attorney is not going to turn right back around and give you that transaction because you did the legwork? Now as an agent, that that property is stuck without getting out of probate. So you are already aware of what it means to be in a probate transaction. So I think that's a really untapped market. And again, I said that was just Miami-Dade. So I guess touching on everything else, this transaction can lead to another purchase or sale. Think about it. These people, when they sell these properties, are coming into money, meaning they may need to buy a new apartment. They may need to buy a new condo. They need a new house, or they're coming into other properties, meaning they may need to sell another property that they inherited in this same probate. So you can essentially be a full circle resource from just that one, lead that comes from this probate. And I guess the last point I want to touch on that I think is super important is know your role in the transaction, get educated, and be patient. If you can show, again, a law firm or an attorney that you know what this process is, that you're educated, that you're timely, that you're professional, and that you know what your role in this transaction is, you're going to create a solid business line that an attorney is going to keep coming back to you and using you for these transactions. And I'll give you just a few examples of some colleagues of mine who have been probably on the bad end with an agent where the attorney themselves has had to go and produce the keys or open up the house, and show it to people. That is not my role in this transaction. Right there, that's leaving a sour taste in my mouth if I'm not only having to do the legal work, but now I have to do the role of the agent as well. So just make sure that you always show yourself as a professional, that you're educated, and that you know what your role is. Make sure that you're on top of it. Just show the attorney that you know what you're doing and that you're ready, willing, and completely on track and know what's going on with this transaction. And then I guess to kind of touch things off, That is my direct contact information. If anybody wants to, meet with me one-on-one, Zoom, phone call, coffee, whatever, I'm more than happy to meet with whoever wants to talk. And, feel free, no hesitation. You can text that number if you like. That's our office line. And you can schedule a Calendly with me if you like, or, like I said, we can meet up wherever you like, but I'm open to any and all conversations and discussions with anyone. And I guess we'll open it up for questions, I guess, at this point.
Yeah, if you guys have any questions, just raise your hand so that way the chat doesn't get too crazy. Just raise your hand for Nicole and she'll be able to answer anything. I don't know if it shows me. Oh, let's see. Leah's got one.
Oh, okay. Sorry. Okay, yeah, I think you said it was Kalia, right?
Yeah.
Okay, yeah, go ahead.
Yes. Hi, good morning. Thank you for
Hi.
the information. I just want to ask that sometimes when I close on a property, I get a lot of questions about how can I protect my property or basically say like to avoid probate. So what could I tell my clients in the beginning stages on what they need to do in order to avoid probate?
So I'm really glad that's a really good question. So that was another point that I also wanted to bring up. Again, that goes back to being a full resource. So I think one of the top recommendations is, always tell them you need to estate planning is probably one of the most important components, especially if they're buying real property, because if not, they're going to end up, like you said, in a probate with the estate.
Deborah, you gotta mute.
So sorry. I think common things you can do is tell them, look, I think you should meet with an estate planning attorney. Hi, that's me. I do probate, guardianship, and estate planning. And common examples are obviously putting the property in a trust. I've done transactions where someone literally wanted a trust prepared for the closing table, and the title company literally that moment, it went from whoever she bought it from straight into the trust, and never touched her quote unquote individual hands. So that's one of the things you can always recommend. You can also recommend the Ladybird deed, which that one's what we call the enhanced life estate deed. They retain ownership and control during the term of their life. And then upon their passing, the beneficiaries designated will essentially automatically own it upon that person's passing. And all they'd have to do is essentially record a death certificate and probably a new, deed. Essentially, it's kind of dumb, but it'll say like, XYZ deceased, to whatever. But who knows? All the county changes their mind all the time, as we all know. But yeah, I think that's a very good thing to always, present to them. And again, that's another opportunity to open the door in a business connection between you and an attorney and a law firm. Because if you go from closing, you transfer your client to the estate planning component, more likely than not, 9 out of 10 times, that attorney is going to throw something back because they know that you see the value in the estate planning to avoid probate. So I think just those two little things are a quick and easy way to be like, hey, I think you should do this, and I think you should talk to this attorney.
Thank you so much. And between the trust and the Ladybird deed, I've always getting questions on which one is better. Do you have any suggestions on that?
It depends on the person's circumstances, what their assets are. If the Ladybird deed is pretty safe bet. Now, I will say the moment something happens with the property during your lifetime, so in the sense of like if they decide to sell it, or if they do a new quitclaim deed for whatever reason, that Ladybird deed is out of the water. That's done, it's over with. The trust, however, provides a little bit added sense of security because once it's in the trust, it's administered by the trustee and per the distribution terms in the trust. So maybe it depends on their budget, because obviously a trust is more costly than the Ladybird deed. But if they're looking for just the all around cover all my bases, I'm going to say the trust. But, sometimes some clients can't afford it or they don't really need it because they don't really have too many assets worth putting into the trust.
Okay. And then trust is like in the thousands to do pretty much, right?
I would say ballpark it, they start around like 2,000, and that's a simple trust. But and again, maybe to some people that sounds like a lot, to some people it sounds like a little, but a probate is around $10,000. So, you tell me.
That's a great point. Thank you so much.
Keshka had her hand up after.
Hi, good morning.
Good morning.
Thank you for the information. You being a probate attorney, how can you give me some pointers of how to solicit your business as a real estate professional? Like, has anyone come to you and solicited your business?
In the sense of, I guess you as an agent trying to get my probate transactions for the sales?
Yes,
Yeah.
yes.
I think the best way to do that is, I think, and I've had people do this before, you can just send an attorney an email or, maybe give them a call if they have a calendar or something, schedule a meeting with them and just say like, look, this is what I can bring to the table. This is the knowledge that I have. I understand these transactions because I think a lot of my colleagues have shared a similar sentiment where they've used agents before that, you're an agent because you're experienced in being a real estate agent and a realtor and just being in this business. But there is a difference with doing that and being involved in a probate transaction because, like I said, it requires knowing a little bit more about the law, knowing a little bit more about the judges and how the timeline of things are. And I know we're all just trying to get paid. And I know we're all like, everyone, money talks, time is money. I get it. But with a probate transaction, you need to have patience and you need to have you have to have the knowledge of what this transaction entails. And I think showing that to an attorney of, I know, the probate process, I know the timeline, I know I have to wait maybe 6 months to a year possibly for this transaction to close. But it's like I said, showing them that you know what's involved, that you know what documents you need to produce to them, showing them, and like I said, even maybe bringing them the transaction and just kind of just saying like, look, this client needs to probate this. I'd love to be the realtor on the transaction if their wish is to sell. They've already expressed to me these are their desires, and I think you'd be an amazing attorney to take this case, and I'd love to be the realtor that does the sale. I think that's one of the ways to kind of show, you need to show your worth. You need to show that you're hungry to get that business, to get involved in learning this particular niche, because there are some realtors out there that sell themselves as probate realtors, maybe even follow those, and maybe even if you can make friends with them and just be like, hey, what did you learn? I know some of them do seminars and stuff like that, or, things like this, meet with an attorney and pick their brain, anything like that that can show your worth to them, I think is worth a lot.
Okay, thank you. That was good information. So the sending the treats to the office don't work, right?
I mean, it may or may not, but I think sometimes for me, I think the personal, like, hey, can we get a coffee together? I'd love to learn about probate. Like, you need to show me that your interest is like learning about this and knowing what you're doing, because the last thing I want is, like I said, I don't want to have to do my part of the transaction and your part. I need to know that you're legit. Like you know your stuff. Like you're gonna get it done. You're gonna be in and out with me. Like if I tell you, oh, the PR is so and so, like get in touch with them. Like I need to know that you're gonna be able to do that, and that I don't have to go out of my way to find my client to sign your listing agreement. You know what I mean? Like make my life easy so I can make your life easy too, type of thing.
Right, right. Okay, thank you so much.
I think Mary might be next.
Yeah, Mary was next. Yeah, Mary Fatima Daniel Lindell.
Good morning. Great morning to everyone. Thank you for for the information. This is right at a situation where I'm going through right now. So I just need some clarity. I have a customer who is actually in probate, and there is no one. They're not contesting the probation. It's between my customer and four other siblings. Well, what else came up was the house, and I don't know if this is true, so help me. The house is in probation, but in probate, but it's also left in a trust. So I was like, I didn't even know you can do that. The house was left in a trust at first, and then the father passed away, and now it's in probate. Shouldn't it have gone directly? I guess my question is, shouldn't it have gone directly to the person in trust? Oh, and then there was another person added to the deed.
Wow. There's so many things wrong with that entire example.
Exactly.
So typically, again, without knowing more and getting involved, once you deed the property into the trust, you wouldn't be able to add someone to the deed unless you deeded it out of the trust into another person's name and then added that person. So you may need to do maybe a chain of title search to verify what happened, because it very well likely could have also been, and I've seen this happen too, people will get a trust created, not fund the trust, because there is a difference between creating a trust and funding a trust. They could have not funded it, which is why the property maybe ended up in probate. But typically, yeah, if it's in a trust, it's gonna stay in that trust. There's no way to get it out unless it's deeded out of the trust. So something must have happened there, that it maybe never even made it into the trust, or it came out and they did what I said, that they started adding people. Another thing might be that all the trustees in the trust and successor trustees maybe passed away, and no, I guess, replacement or secondary successor trustee ended up getting appointed, which typically at that point, there has to be a provision in that trust that provides for what happens when we run out of people, whether it's a professional trustee, corporate trustee, something like that. So I think step one, maybe do a chain of title search, verify, that it was ever even in the trust, because otherwise it shouldn't have ended up in probate. And then if it did get funded into the trust and it came out, we know what happened there. So that's kind of like problem solved. But I guess, yeah, the probate component, yeah, I mean, if it's in probate, it's in probate. But I would definitely verify the chain of title on that. I think that's for sure step one, and just ensure that. And then maybe out of your own curiosity, see if they'll provide a copy of the trust or a certificate of trust, which kind of has like the simplified information of the entire trust document. So to kind of get like a grip of the storyline and how this played out, because that's the thing with probates. They kind of tell a story to some degree.
Yes, I talked to the attorney. Well, I left a message. I went over to the house because I was very curious. I was like, how can they do that? So, like you said, the first person that they had the house in trust passed away. They created a different trust. I don't know if it was recorded. And so and I have the paperwork to prove, but I'm waiting for the attorney to at least give me some feedback, because I'm scratching my head for this to be my first probate transaction.
Yeah, no, definitely. Yeah, verify that, because again, if it's not recorded, it could be just that situation where the people made the trust and never funded it, which is very common. A lot of people, sometimes people like to give money away. That's fine. That's on you. I don't do that. But some people will make a trust. I have a client right now. They made a full estate plan in 2000, I think something 2006, 2007. never did anything with it, and they're like, yeah, we need a new trust because we don't want what that was, and we never even funded it. So that could very well likely be
Oh,
the
okay.
circumstance, because you could creating a trust, just so you understand, it just creates like a little shell, basically. It's like a little mini corporation you create, but you got to put stuff in it. It's like you open a bank account. Just because you open it doesn't mean money's in there. Like you got to put stuff in it.
Oh, okay.
So
Okay. Well, thank
verify
you.
that. And if anything, send me an email. We'll talk it out.
Yes, because it's baffling me, and I'm trying to understand. But okay, thank you. I will be in touch. Thank you.
Okay, Fatima, I think it would be the next one.
Yeah, Fatima.
Hi, good morning.
Good
Hi,
morning.
I had a similar question about the trust that was asked previously. However, I wanted to know if if a homeowner passes away and they have a will and they designate who they want to leave their property to in the will, what is the difference between doing that and opening up the trust if they don't have that many assets, if their home is their only asset?
Okay, great question. And I think a lot of people don't know what I'm about to explain. So I'm glad you asked that question. So a will is great, that's awesome, but a will does not have the legal authority to transfer title and ownership in an asset from a deceased person to the subsequent owner. The will is literally just my wishes and desires. This is what I'd like to happen. But the will, you can't go to the property appraisers and say, well, my grandma's will said I'm supposed to get it. No, that's not how it works. The will is great when you end up having to probate it. And that's the thing with a will. A will is a document intended to go to probate. It's meant to be essentially submitted to the probate court and deposited, administered, and go through all of that. So that's the biggest distinction. A will cannot change title. It's just my hopes, wishes, and dreams. That's what a will is. The trust, once it's in there, that trust essentially provides, and again, this is assuming you tell your attorney, this is what I want, this is who I want to receive it. The trust will have a specific beneficiary designated for almost all assets, or it'll have some sort of distribution scheme. So you can put, let's say, 6 properties into a trust, and you can say 1, 2, 3 South Miami will go to my daughter. XYZ Street will go to my nephew. It has the people so that when the triggering event occurs, whether it's the initial owner passing away, or if it's a person reaching a certain age, because that's things that you could put in a trust. I don't want this person to receive it until they're 25, until they're 30. When the event occurs, that's when the distribution will happen. So, I think that's the biggest difference. The will has no teeth, the trust does. You don't need anything really more with the trust other than to make sure you have a trustee who can then distribute assets accordingly to what the trust says.
Okay, got it. Thank you so much.
Okay, Daniel?
Hey, good morning. Good morning.
Good morning.
Thank you. Thank you for the information. I had quite a few experiences with probates. I was blessed enough to have not done a full-blown probate and was able to sell properties with the summary to sell because property was homesteaded and they had the summary of administration. So we was able to move forward doing the probate because we didn't have to wait on assets. And so the probates was never a long journey for me. Plus I was, knowledgeable about what they should file. But I do have a situation I need help with you with. Just to give you a brief understanding. So a couple was married. The wife died. The husband lived, and he had no kids. Then he died. All his siblings died, so he don't have no brothers and sisters. But the nieces and nephews are alive. The nephew want to acquire the property. He has his uncle death certificate, but cannot get the wife's death certificate. And we had to stand still right now because, you know, the probate needs everything to get started. And I'm stuck right now because I don't even know how to get someone's death certificate he's not kin to. But that was his auntie-in-law.
So okay, so if you have, and again, I think my law partner always says I have a way of getting people's death certificates. I don't know how, but I'm like 10 for 10. So typically, as long as, and I might have one of those forms here, I think, and I don't know where you guys are located, but I have, and I know this sounds like I can't believe the attorney goes in person, but yes, I do, because if I need to get my death certificate, I'm going to do it. If you're familiar with Miami Gardens area, there's a Vital Statistics there by American High School. And there's a few of these locations throughout Florida and Miami, essentially. You can go in person and fill out those little forms as long as you essentially have their date of death, their name, at least the county where they passed away in. What else? If you have their date of birth, even better, because it helps the representatives kind of like pinpoint the person. You can essentially obtain the death certificate that way, and you can obtain it in person. It's $20. I mean, I've done it a million times, and I've been able to find people that I've even gotten the wrong name from, you know, the family members. They spelled it wrong. I've even had people give me like 5 years difference, you know, but I was able to find the name, you know. So you can obtain a death certificate almost really, you know, like a niece or a nephew can definitely obtain it without a problem. The only times they get a little sensitive about it is if you're looking for the one that has the cause of death, which for probate, you don't need the one that has the cause of death on it. So you should be fine. And if there's an attorney doing the probate process, they should easily be able to get this death certificate the same way I do, you know, and unless they passed away, I think it's prior to, I think it's 2005 or 2006, something like that. If they passed away prior to that, you got to mail it in and request it, blah, blah, blah. It's a process. But otherwise, you can go in person. I mean, and I think you should be able to get the death certificate in that way, and you should be good.
Okay, perfect. Thank you. I appreciate that. Thank you.
Okay, and then I think Donald.
Yeah.
Good morning. How you doing?
It's already 10:46. Good morning. Good morning, Donald.
Good morning. Quick question. Thank you for all the information. I have a situation where the parents have passed away and they have one living child, and she's actually on drugs. How do you go about trying to even start a probate case with this individual kind of being lost in the wind?
If there are no other next of kin or beneficiaries, it's literally like there's no siblings to mom and dad or nieces and nephews of any kind. Is that?
No, there's not.
Nothing?
Nothing. Just
Nothing.
her. That's it.
I mean, here's the thing, and I'll give you the reality. If there's no adjudication over the daughter being incapacitated, or there's no, you know, judicial determination that she doesn't have capacity to do or sign things, you can essentially proceed with that individual now. With that being said, they cannot, to be PR, you cannot have any kind of felony or essentially criminal background of any kind, because you're supposed to do an affidavit of no criminal history. So if the daughter is, you know, essentially in that capacity, then you might have a problem there. You can get a third party. So for example, I've seen it where attorneys will serve as the PR of the estate. You know, the attorney representing, you know, the beneficiary can serve as the PR. That's an option. You can get a different professional, you know, what we call a fiduciary, to serve as the PR. That way, you know that someone that's responsible and knowledgeable is, you know, administering the estate on behalf of these individuals. With that in mind, personal representatives are typically entitled to, I believe it's 3% of the estate, more or less, give or take, you know, some sort of figure like that. So an attorney may say, okay, I'll charge my fee plus the 3%. Some may say I'll just charge my fee, but there is essentially a workaround to not having the child serve as the PR if there's concern for misuse or their, background record is concerning of some sort.
Okay, thank you very much for your time.
Hey, good morning, Keisha.
Good morning. Good morning. Thank you for the information, the wealth of information. My question is, if the client has a trust and a will, and they want to transfer or fund the trust with their asset, how does that work?
So it's pretty simple. One of the things that typically if you create an estate plan or a trust, your attorney should be able to fund the trust for you. I like to fund the trust for, our clients because I think it's in their best interest to already have it funded. But typically we also provide a letter to client that it basically says, okay, after we fund this, you have to title the title in the asset needs to be titled this way so that it can move from whatever current title it's in to the trust. And it's typically, I'll use myself as an example, Nicole Soto Ortega as the trustee of the Soto Ortega Family Trust dated XYZ date. By doing that essentially that phrase on that, you are giving the transfer authority from that asset there into the trust. So it's typically a phrase, and that's the phrase that I'm referring to that transfers ownership of the asset from whatever state it's in into the trust. And like I said, that's something at our office that we like to provide our clients that says, these are common assets that you can fund your trust with. And if after we fund it, there's something that comes along the lines that you want to fund it, this is how you would do it. So that's basically, it's just a titling thing and making sure that you record it if it's a property, and then you make sure you update it if it's a bank account or something like that.
Okay. I believe the problem is also they're having a hard time to find an attorney because of the client age. So if they're close to 100 years old, nobody wants to take the case.
If they have capacity, it should be okay. But we've done it before where we'll meet with clients to kind of do our own self-assessment to kind of assess, like, do you understand what I'm asking you and stuff like that. I think, by all means, give my office a call. I don't mind meeting with a potential client to kind of assess them and see if I'm comfortable, doing the work for them. But sometimes if a person is a little too far, removed from reality, sometimes you do risk, not being able to get something prepared.
Okay. I'll give you a call. Thank you so much.
Thank you.
Thank you so much, Nicole. If you can put your information back up on the screen for everybody. I know Precious was asking about it. That way everybody can reach out to you.
Yeah, I'll also dump it in the chat too. Where is it? And then sorry, I'm just putting it.
No worries.
Let me know if you guys can see.
Yeah, we see it. So you guys, you could take a picture of this or a screenshot, call Nicole with any questions that you have in regards to probate, figure out how you guys can partner with her to get some business going on your end. I think searching the estate of on Miami-Dade, I did do it while she was talking. There was 6,124 of them. So you can find your area, farm it, go to those properties directly, mail to them, and see what's going on in their process. If they haven't started the probate process, you can connect them with Nicole. That will be a good start. And then that way you have that deal coming in 6 to 12 months down the line in your pipeline. But anything that you guys need, her information is there. Thank you all for coming. We'll be back next Monday. How to do the search. You just go on Miami-Dade Property Search. You just go on Miami-Dade Property Search, and instead of searching by the address, you search by the owner name, and you just type in EST of. Pretty simple. I'll send you guys a screenshot of it, of what it looks like. But thank you all for coming. We'll be back next Monday. Have a good week.
Thank you.
Thank you, Mike.
Great. Thank you, Mike.
Thank you, Nicole.
Hi, thank you.
Thank you, Nicole. Thank you, Mike.